have tonight Professor Jill Staufer, who is Associate Professor and Director of the program in Peace, Justice, and Human Rights at Haverford College. She's on the board of directors for the nonprofit book series Voice of Witness, which illuminates human rights crises through stories of women and men who live through them. Her academic interests include philosophy of law, political philosophy, continental philosophy, and ethics. She has published articles on practices of hearing that succeed or fail, legal and political responsibility, political reconciliation, child soldiers, settler colonial silences, and the rule of law. Her edited volume, Nietzsche and Levinas, After the Death of a Certain God, was published by Columbia University Press in 2009. Her book, Ethical Loneliness, The Injustice of Not Being Heard, was published by Columbia University Press in 2015. And she is currently working on a book called Lapse Time, Interruption and Resistance in International Law and the Settler Colonial State. Pretty sure that the material she's going to present today is related to that research. Today she's going to give us a paper entitled The Closest Thing That Comes to My Mind, Law, Genocide, and, remind me? Decolonial Hearing. I know it, I forgot it. So I'd like you all to join me in welcoming Professor Jill Staufer. Thank you.
Hi, everyone. Thanks for taking the time to come out. Tonight, I'm going to talk about some ideas about time and their relationship to historic and continuing injustice imposed on Indigenous groups in North America. To do that, I'll talk about a legal case from what is currently called Canada, in which Indigenous groups sought to claim sovereignty over their land. Canada added an amendment to its constitution in 1982 that has bearing on this case. Section 35 of the Constitution Act of 1982 states that, quote, "The existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed," end of quote. The purpose of that clause is to recognize that Indigenous groups have rights that are prior to state power, that is, rights that were not granted by Canada. And that opens up the possibility of really interesting legal decisions. So far, unsurprisingly, no thoroughly liberatory decision has been made by any court in Canada. We're all in the grips of the era of settler colonial domination. And this case that I'm going to talk about tonight helps make clear that genocidal intent may be built into settler colonial forms of law. And that's part of why I'll also be looking well beyond law as I discuss how to view this problem. So first some background and then some philosophy. In recent years, courts in Canada and the US have begun to accept oral histories of Indigenous groups as valid evidence rather than dismissing them as hearsay. Let's make clear what that means. Hearsay, from a legal standpoint, is a complicated term, but in general, in a court setting, if someone testifies that someone else said something, that's considered hearsay rather than evidence. It's considered hearsay because the statement, "Marie told me she saw Howard there," can't be verified in the same way that the statement, "I saw Howard there," can. Marie's not under oath and she's not available for cross-examination. So since stories in an oral tradition have been passed to third parties by someone else, have been passed from third parties to those who testify, they might count as hearsay if courts didn't consider the larger picture. The larger picture is that many Indigenous groups, in those groups, oral tradition is the means for storing cultural information, such as rules, geographies, spiritual practices, and histories. So these stories ought to count as evidence because for the cultures in question, they function similar to how legal documents function for settler colonial legal institutions. This small step, admitting oral history as evidence rather than excluding it as hearsay, already involves us in a discourse about time. From the standpoint of a liberal progressive view of history's unfolding, admitting oral history as evidence seems like a step forward in which law expands and becomes more inclusive and responsive. But a closer view reveals that those making judgments in these cases rarely are able to hear what's being said by Indigenous persons telling oral histories in court settings. The worldview, language structure, conception of time passing, and ideas about geography, culture, spirituality, and community may differ so radically from those in the dominant culture that, unless judges presiding over settler colonial courts learn enough about what oral histories aim to do and how they do it, they will impose legal injustice. That creates a situation where settler colonial subjects, and by that I mean any of us who may have arrived on this continent relatively speaking later than Indigenous groups. So what I'm saying is that if we and our judges don't learn enough about oral histories in order to be able to hear them well, that creates a situation in which many settler colonial subjects may feel good about progress, which is one story about how time passes, while Indigenous groups and their allies recognize this as a continuation of a very old plot of assimilation and extermination, which is a different story about time's passing. Related to that, the philosophical aim of this talk will be to look at how settlement gets lived as an unquestioned reality by white settlers, and how different accounts of temporality and of storytelling might open up that reality to questioning and the possibility of radical transformation. And that type of transformation would contribute to ending what is genocidal about settler colonial law. So I'm going to present the argument in 9 short sections. It should take about 40 minutes, including everything that I've already just said. Okay, so section 1 is called Mook v. British Columbia. I should have put the strange words up on the board, but there's something about their strangeness that maybe speaks for itself. So, Mook v. British Columbia is the legal name for the case brought by the Gitxsan and Wet'suwet'en peoples claiming title for their traditional lands in what is currently called British Columbia, Canada. A key piece of information in the case is this: these lands were never relinquished by treaty. The Gitxsan and Wet'suwet'en peoples have lived there for hundreds of years or since time immemorial, depending on whom you ask. Mook is the name of one Gitxsan hereditary chief, but the suit was brought by 54 chiefs from various houses of the Gitxsan and Wet'suwet'en peoples. In bringing suit, they sought legal recognition of what for them is an established truth, that the land in question is now and has always been their land. This case inhabits a zone where law passes judgment on the passing of time, and in so doing enacts one temporality rather than another, all without acknowledging that it has the power to do that. In his opening statement in the case, Mook asserted, quote, "We do not seek a decision as to whether our system might continue or not. It will continue," end of quote. This declaration asserts sovereignty, and it also voices a view about time. My sense is that your typical judge or settler colonial subject can hear the assertion of sovereignty, but not the idea about time. That's probably because it's easier to see Indigenous land claims as claims about justice than it is to see them as claims about time, in part because most settler subjects are too confident that they know what time is and that it is just one thing. I'm going to explore what's wrong with that confidence today because I think it opens up possibilities for interrupting settled thought patterns of settler colonial subjects. I'm pursuing this line of thought because I think it's an urgently needed practice of justice. It's one thing for courts to make rulings and truth commissions to issue recommendations. It's another thing entirely for an entrenched worldview to shift such that what was once viewed as an unquestionable structure of the world is experienced by people who benefit from that structure as an inexcusable form of domination. What I mean is, what would it take for settler colonial subjects to really see, hear, and feel their implication in an ongoing injustice? I'll assert my belief that institutions cannot accomplish this on their own. Settler colonial subjects residing in Western democracies may think their political systems are fair, just, and equal, but often, if they do acknowledge past injustices, they don't see that the past injustices continue in the present moment, kept in place by how settlers live in settler colonial societies right now. In short, because they do not consider that things could be otherwise, they do not realize that they are at least in part responsible for how things are. That's why I want to spend a bit of time thinking about how to create interruptive moments. Section 2 is called Common Sense or Perceptual Tradition. A moment ago, I suggested that cases like Mook inhabit a zone where law passes judgment on the passing of time, and in doing that, enacts one temporality rather than another, without acknowledging that it has the power to do that. We might call this temporal privilege. If citizens of land that was taken from earlier inhabitants do not feel implicated in an ongoing injustice, how did that denial become possible, and what makes it able to continue in widespread fashion? Such privilege is part of what the phenomenologist Merleau-Ponty would call a perceptual tradition. A perceptual tradition is an accustomed way of seeing and interpreting built up over time by the way people live together, what they value, what they look at, and what they don't see. Mark Rifkin calls this settler common sense, by which he means the way non-native settler colonial subjects rely on framings of the world that normalize settlement as the background truth against which experiences of the world are interpreted, and thereby render other possible framings of the world illegible. Of course, we all rely on some already established facts and procedures in our daily dealings with each other so that we can focus on what is new and challenging rather than having to reinvent every wheel. Common sense isn't all bad. But sometimes common sense makes us forget to notice that much of what we accept as given is not really given, but rather is stipulated and then adhered to over time in largely unthought ways. In our daily lives, common sense presents many of our choices to us as if they were simply how the world works, and thus we don't always see that these are choices and that things could be otherwise. Another part of the problem resides in how settler colonial histories get told as the progressive realization of an inevitable expansion of territory, obscuring other possible tellings. We might call this lapse, a failure of memory or a piece of a larger picture gone missing. When a story of settlers settling on land is told as preordained or unproblematically legitimate, there's a lot that has to remain outside that frame. Here's an example set in the 19th century United States, but connected to the present moment with a continuous thread. Lapse occurs when the 1862 Dakota War is described by settlers as criminal behavior by natives, rather than sovereign self-defense in the face of long-standing injustice. Settler common sense perceives native self-determination as a temporal aberration, as if challenging white settlement were a refusal to live in the present moment, or a failure to recognize a future that is assumed to be inevitable. Settlers think this way in part, at least, because nothing in their perceptual tradition allows them to see the decades-long slow-motion onslaught of injustice and deprivation that leads up to the Dakota War. The official colonial story of native disappearance supports the received idea that inevitable national expansion is simply what time is, rather than one accounting of time's passage. The same story would look different told from the standpoint of the Dakota, who neither acquiesced nor disappeared in any simple way, and whose longstanding stewardship of the land would give voice to a different experience. My point is that we've all learned how to see, where to look, and what to think about what we see when we look, and what that means is that there's a lot we don't see. Here's a more recent version of lapse. The protests at Standing Rock against the Dakota Access Pipeline were largely framed by media as an issue for law enforcement. That is a kind of settler common sense. After all, the protest is not only about water, but about the sovereign right of the Sioux to control developments that impact their land and livelihood. And multiple treaties support the claim that the land in question belongs to the Sioux, even if the US has not honored the treaties. Calling what happened at Standing Rock policing attempts to evacuate native tribes of their sovereignty by assuming that the conflict consists of criminality and law enforcement rather than an insistence on self-determination. What would we see instead if we interrupted the perceptual tradition of settler colonial subjects and looked at the #NoDAPL movement as a form of continued self-assertion by Native Americans, and then we saw the state's response to it as continued repression of that self-assertion? What I'm doing here is questioning whether what settler colonial subjects take to be settled is actually settled, and that too is a question about time. Section 3 is called lapse. So a lapse is a failure of memory or a piece of a larger picture gone missing. It's important to mark what's negative about a lapse. Settler colonial ways of perceiving and inhabiting worlds fail to acknowledge, to remember, to appreciate, and to honor as equal Indigenous lives and Indigenous ways of world building. That's an ethical failure with deadly consequences. It's also important to draw our attention to what may be positive about a lapse. A lapse, when identified, stands as evidence that no system is universal. It points to something missing from a commonly accepted picture. No regime, no perceptual tradition encompasses all truth. And so the unintelligibility of certain ways of thinking may have positive value, pointing us toward resources and modes of resistance that already exist or are struggling to come into being. Change can emerge from sites like this. Precisely because any way of thinking is the result of training and not a reflection of an unchangeable nature, subjects trained to think inside one system can learn to listen for what that system cannot contain. So lapse is not only negation, but has a positive value. If you're wondering where you might find a lapse in your own daily life, just look at the person next to you. Other human beings are just that, other. And thus, no matter how much common sense we may share, every human being will retain the possibility to surprise, resist, to defy expectation, to disappoint, enrage, inspire love or admiration, and so on. There's something about any other person that no amount of your thinking about them will ever fully encompass. That's also lapse as something other than negation. The lack of transparency is not only invisibility or silence, but an opportunity, a site where something unexpected from within what you already think might come into view. So, speaking of dominant framings, what's the lapse that allows settler colonial citizens to consider themselves unproblematically free on land that is legitimately theirs, and what might productively interrupt that certainty? Legitimate ownership of land in this context is granted by law, but that law is built on a deep history of theft and injustice. Learning to see that might help people think differently about what it means to dwell together with others on land, or teach us to admit that land's provenance can't be entirely determined by property law, just as time's passing can't be contained in one temporal rendering without showing the signs of a lapse. Section 4 is called Oral History as Evidence. For both Gitsan and Wet'suwet'en peoples, tradition is stored in oral narrative and material culture. By tradition, I mean a broad range of rules, history, spirituality, geography, and cultural norms and aspirations, all of which may not be separable in the same way that they might be separable in North American settler colonial traditions. The Gitsan oral histories are called Adawik, and the Wet'suwet'en are called Kungak. A website for the Gitsan people describes the Adawik this way, quote, "Each wilp or house has an Adawik or oral history which describes important events in its existence. The carvings on a totem pole record parts of a wilp's Adawik. The Adawik is tied to the territory, and events depicted by the crests on totem poles signify jurisdiction over a certain territory by a wilp and its hereditary chief," end of quote. So an Adawik serves to record house ownership of land and resources. A pole serves as a material sign of those responsibilities. And performing these histories at feasts is what the legal philosopher Robert Cover would call juris generative. It creates law. In court, the oral narratives were used as evidence that the Gitsan and Wet'suwet'en houses ought to be granted sovereignty over, or at the very least, title to their lands, whereas in the lives of these indigenous peoples, these oral histories are title, or there's something close to the Western legalist idea of title. That a story or a poll or a song could be legal title should have been an interruptive moment. It should have stopped everyone in their tracks and sent them scrabbling to understand how this universe of meaning builds worlds differently than does Western legalism. Indigenous oral traditions don't conform to legalist expectations about evidence, nor do they reward assumptions that settler colonial societies harbor about how narrative works, perhaps especially legal narrative. The stories lack set beginnings and endings. They might change according to their setting and their purpose in a given situation, and they implicate the listener as much as the teller. Julie Cruikshank points out that oral history, quote, "survives not by being frozen on the printed page, but by repeated retellings. Each narrative contains more than one message. The listener is part of the storytelling event too, and a good listener is expected to bring different life experiences to the story each time he or she hears it, and to learn different things from it at each hearing. Rather than trying to spell out everything one needs to know, it compels the listener to think about ordinary experience in a new way," end of quote. Stories that told this way implicate those meant to hear them in an ongoing work of world building. Lee Maracle writes about how oral and written storytelling functions for Coast Salish people, another indigenous group in British Columbia. She calls the process collaborative and collective, not in the sense that everybody has to agree, definitely not, but that many participate. Oral tradition, or even a written story that aims to not only deliver set rules, but to provoke in the hearer a duty to interpret how to live, guides its subjects to build worlds and implants responsibilities. It is juris generative. It creates law. Or, as Maracle puts it, quote, "Story becomes a means of intervention preventing humans from retraversing dangerous and dehumanizing paths," end of quote. That might also be one of the aims of settler colonial law, though what animates its practices differs. So the stories don't conform to legalist expectations about evidence or settler colonial assumptions about how narrative works. However, on my reading, it should be clear to anyone who truly listens that stories like this exist in order to bring into being and then sustain a world, much like Western law does for many settler colonial citizens. But it's important to note that these stories inhabit both time and language differently and aim to build a different kind of world. Learning to hear them is one way that settler colonial narratives might get interrupted. Section 5 is called Goat Story. An Adawak is normally performed for people who accept its authority, understand where it comes from and what it aims to do, and honor it for its role in their lives. In Mook v. British Columbia, portions of a few different Adawaks were performed in court for a very different audience in order to provide historical evidence for continuous ownership of land, describe Gitsan social structure, and meet the organized society test prescribed by Canadian law. A woman named Gwans, also known as Mrs. Olive Ryan, shared part of an Adawak dealing with a historical event. The point of the story on my reading is to teach listeners to attend to their relationship with the non-human world and to treat animals and land with respect. But note that when I isolate what the main point is, I'm already going against the spirit of the genre, which is to be more than that. Gwans reports that young boys were treating some goats badly, mocking them and throwing small ones on fires. One boy felt bad about this and protected a small goat. Later, goats who had made themselves look like human beings build a village and invite Gwan's ancestors from an ancient village called Tamlak Amit to a pole-raising feast. The secretly goat people gather the visiting villagers into what looks like a community hall, and then the building collapses during the feast, killing everyone except the boy who had helped the small goat. So the goat who had been treated well helps the boy who treated him well, whose name is Ant Golulbik, back down the mountain, and the boy returns to Tamlak Amit to tell everyone. As Gwans puts it, quote, "They don't allow us to make fun of those little creatures. That's why they said to the young people not to make fun of animals, because the creator's going to get mad if you mistreat them." That's what grandmother said. The creators will laugh at everything. The man and the girls and the boys that are created, they created in this world, end of quote. In the Adawak, the people of the village make sure their children know to treat animals with respect, and the one-horned mountain goat becomes the crest of the Ant Golulbik house. After this event, everyone moves from Tamlak Amit to Gitsagukla, where they've been ever since. This story establishes a long history of the house feast, makes points about deeply held beliefs about the human relationship to and respect for nature, and demonstrates control over one portion of land and reasons for moves to another site. Section 6 is called A Bear Problem. The current Ant Golulbik, Mrs. Mary Johnson, tells a story from another Adawak based in that same village, Tamlak Amit, about a very large bear with great powers that causes a landslide that crushes all the warriors that try to combat it. The bear seems to have been angered by some women who were playing around with trout bones and taking more than they needed from nature, and thus the bear was provoked to attack the village and destroy it. This story functions like the goat story as a way to warn against treating nature with disrespect, and it also offers reasons for a move from one location to another. You can see why settler colonial subjects immersed in a perceptual tradition that takes settlement as an unquestionable fact of the world may doubt that all of this is true in the way that Western legal truths are true. But that misses the point. Adawaks exist as documents of long-standing relationship to land. Read as a whole, and placed alongside various other historical sources, they should be enough to support the claim that the Gitsan are an organized society with a deep historical relationship to the lands they claim. Heard as a complete system, it proves legal occupation over time. One might need to take some time to learn how to hear these claims as legal claims, but I do think it can be done. Lawyers trained in the Western legalist tradition tend to seek to show that the narrative forms of oral tradition, when taken apart and subjected to the standards of an alien culture, begin to fall apart. The different parts of the stories don't add up. But how, in turn, might the earth-destroying and genocidal forms of settler colonial capitalist legalism also get to begin to fall apart if subjected to the logic of a more respectful and sustainable relationship between human beings, animals, and earth? A key question here is, who gets to decide which story makes more sense? And now we'll get to what I'm calling the bear problem. After presenting all of the Adawak-based evidence, the lawyer for the plaintiffs asserts that the Adawaks are told in court for the truth of their contents. The judge interrupts with this question, quote, "Well, Do you advance Mrs. Johnson's evidence about the destruction of the village by a supernatural bear as proof of that fact? End of quote. The lawyer insists, quote, it's clear from evidence you've heard that the spirit world, the animal world, and the human world in many aspects of history are interrelated, end of quote. It does not seem to be clear to the judge that this is so. The judge complains, quote, I don't have any trouble with the proposition that the Edawic or the oral history of these various houses is admissible. My problem is to define what is the Edawic, and that's the difficulty I'm having. I've heard evidence of what I would describe, and I don't say this pejoratively in any sense, but the closest thing that comes to my mind is mythology. And if the witness says it's part of the Edawic, am I bound by that? End of quote. So the judge can't imagine himself being bound by what he calls mythology, what a more generous reader might recognize as different cultural expressions of history, law, and social norm making. At the same time, and this is key, he never questions the conditions of the production of the history, law, and social norm making over which he himself presides. And if he did question it, he might come to see that modern law is as much of a mythology as is the story of the powerful bear that he can't make himself hear. So here's a question. How might we dislodge the certainty of someone entrenched in a settler understanding of law and procedure, such that a story about a powerful bear or goats who make themselves look like humans could be heard as world-building accounts corresponding to legal title to land? Section 7 is called Legalism's Response. After 3 years of hearing testimony and argument, Judge McEachern, the judge in the British Columbia Court, ruled that the Gitxsan and the Wet'suwet'en had no standing to claim existing rights because their rights had been effectively extinguished by Canadian law prior to the 1982 Constitution Act. The legal argument for this is not very convincing, but it's based on the colonial assumption that legislative enactments intended to grant unburdened title to settlers were legitimate exercises of power and therefore effectively removed the rights of First Nations to land. This is a bad ruling because it's contrary to various precedents that had already been set in Canadian law, and also because, were you to read it, it is full of racist assumptions, some of them not even trying to hide under polite language. So it aims overtly to destroy the possibility of Indigenous sovereignty and therefore is genocidal. Mook was appealed to the Supreme Court of Canada, where it got a better hearing. That ruling affirmed that the Gitxsan and Wet'suwet'en people had not lost title prior to 1982. It also made clear that oral history must be accepted as valuable evidence and heard fairly on its own terms. However, it did not grant sovereignty or title to the Gitxsan and Wet'suwet'en. Chief Justice Lemaire, in rendering the court's judgment, ordered a new trial so it could be retried, but also discouraged a new trial, advising the parties that negotiation would be better suited to a fair solution to the problems at hand. Many people call this a good outcome. But there's more to it than that, and this is how genocide may be built into law even when it's trying to do justice. According to international law, genocide occurs when certain acts are committed with the intent to destroy, in whole or in part, a national, ethnic, racial, or religious group. Acts that qualify include killing members of the group, causing serious bodily or mental harm, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, or forcibly transferring children of the group to another group. Succeeding in genocide is not necessary in order for it to be a punishable offense. Attempt, complicity, incitement, and conspiracy count as well. The history of North America post-conquest should be enough to make a good case for my use of the word. By means of war, law, outlawing of customs and languages, removing children from their houses and forcing them into schools that aimed to kill the Indian in the man, forcing vibrant cultures onto reservations, taking sacred land integral to cultural survival, and cheating Indigenous peoples of valuable resources, settlers of North America set out with intent to destroy, in whole or in part, those who were already there when they arrived. What the Mook case shows is that settler colonial law, at present, may continue that work, even when it is also trying to do justice. So here's what I mean by that. The Supreme Court judgment requires that the courts come to terms with oral histories of Aboriginal societies, and it also acknowledges the difficulties of explaining Indigenous relationships to law in the terms of common law property law that we are used to in the Western tradition. But the court's description of what Aboriginal title consists in doesn't do much to move beyond colonialist thinking. If tribes are granted title, it includes a right to exclusive use or occupation of the land for various purposes, but the land use has to be compatible with the nature of the group's attachment to the land, with the implicit understanding that if there's any conflict over that, the court decides what that means. If a tribe ever wants to use the land for something not compatible with that nature of the attachment, then those lands have to be surrendered to Canada and converted into non-title lands. So let's say the tribes want to do something with the land, like lease it to a golf course. Then they basically have to allow a foreign legal system to dictate the outcome. Also, if title lands are needed for a broader purpose, then Aboriginal title may be infringed by state power. And the list of things that count as qualifying are agriculture, forestry, mining and hydroelectric power, the general economic development of Canada, protection of the environment or endangered species, and the building of infrastructure and the settlement of foreign populations to support that. So the ruling that oral history must be treated with respect also determined that Indigenous sovereignty basically cannot exist. In 2014, the Chilcotin First Nation was granted title to its lands by the Canadian Supreme Court, and the conditions developed in the Mook ruling apply. The Canadian government can still pursue economic development on titled land against title holders' wishes if it can show a need that is pressing and substantial. This is about as much of a victory as one could have in a Canadian court at the present moment, and it is a positive development, but the truth remains. The idea that Indigenous groups hold rights that were not granted by Canada grows thinner the more closely you look at it. So to summarize, the racist bad ruling is genocidal in that it aims to undermine the legitimacy of the systems of governance of the Gitxsan and Wet'suwet'en peoples, while leaving Canada's sovereignty unquestioned. The Supreme Court's better ruling is also genocidal in that its ultimate aim is to dictate what counts as Indigenous land use and then convert anything that doesn't fit within those dictates into treaty land governed by settler colonial rules. So it does not create any space for Indigenous self-determination. All right, 2 more sections. Section 8 is called logic. And for those of you who are here for philosophy, we'll get back, we're back there now. For those of you who aren't, sorry. Okay, so let's return to the idea of lapse with which we began. I said that a lapse is negative. It's a piece of time or a different temporality missing from an account smoothed over to look seamless. But a lapse also has a positive resonance. It points to something missing if we learn to look for it. We'll find lapse in any account of settler colonial history that frames territorial expansion as always already inevitable, or requires that Indigenous truths must reside in a timeless past, or dictates what the terms of citizenship or the terms of tribal membership must be, or outlaws the feast structure that sustains a culture, or educates Indigenous children in residential schools, or attaches self-determination to Western legal ideas about sovereignty and land ownership, and so on. Lapse is a feature of settler colonial truth. When we hear stories in court or elsewhere, we might like to think that failures of communication reside with the speaker, and that any failure means that she who speaks ought to learn to do a better job. But when we know more about perceptual traditions and the forms common sense may take, it becomes clear that sometimes no space is made for hearing, and so the fault may lie with the one who thought she was listening, or the fault may lie in the way human beings adhere unthinkingly to structures where certain kinds of speech may not be heard. A colonial court declaring that it has jurisdiction to decide whether Indigenous groups have jurisdiction over their own lands is one such faulty space. So let me make a point about reasoning or logic. That a system is a totality and yet has an outside may appear to logic as a problem. How can something be total and yet not include something? Or how can Indigenous groups have sovereignty if they're part of a North American sovereign? But those types of questions only pose a problem if you stay within the system that claims it is a totality. What if your aim instead is to show that no system succeeds fully in being a totality? There's always an outside, something more. If that's your aim, then the objection that it defies logic to find a surplus to a totality doesn't make sense. So a philosopher or a lawyer might say to me, you can't expect me to accept an argument that defies logic, but I might respond, why do you assume there's only one logic operating here? The philosopher's objection is similar to the idea that we can't make dependable legal judgments based on forms of evidence that feel unfamiliar. It assumes that jurisdiction, by which I mean what counts as law and who gets to judge, is already settled rather than being the very thing at issue. As I pointed out earlier, calling something settled is always also a way of making a claim about time. So to relate this back to the problem of settler common sense, you say, this is how we have always done things, and I'm skeptical of the truth value of your statement, even if you can show me valid evidence supporting your position, not because I don't believe in facts, but because I'm aware of how the colonial frame limits what many of the words mean in the phrase, this is how we have always done things. My sense of what logic dictates and how words work has been interrupted by a competing temporality. That is interruption as a practice of justice. Let me say the same thing differently. Yes, it does push beyond the edges of Western legal reasoning to include a bear with unusual powers or goats who make themselves look like humans in a description of territorial ownership. But what does a citizen of the United States or Canada have to say when asked to describe why she has any right to live on the land where she lives? If I've accomplished anything today, I hope it includes showing that if we look at the big picture, property law cannot on its own offer a satisfactory answer to that question. And learning to hear what Indigenous groups say is one way to interrupt the interpretive inheritance, the perceptual tradition, that makes us think colonial settlement is settled. All right, the final thing is called time. I've been saying that there are multiple temporalities at play when we subject Indigenous worlds to colonial rules, but I haven't been very specific about what that means. One way to think this is in the form of a question. What would it mean to call a history of law that retrospectively authorizes theft and lawlessness for some at the expense of others a shared history? What exactly is the history that settler colonial subjects share with Indigenous groups whose lands have been taken? Rifkin observes that, quote, for things to be simultaneous, they must be situated within a single frame of reference, end of quote. If that's true, does native dispossession really happen in the same time as settler claims to property? Do defenses of water and self-determination really happen in the same time as policing operations that criminalize peaceful protest? Do lawsuits seeking Indigenous jurisdiction over territory never ceded really happen in the same time as settler colonial court rulings that have every confidence that it is within their jurisdiction to decide? I've tried to show that a structure of lapse, for those who learn to look for it, may produce subjects who encounter unintelligibility and see in it a sign that more work needs to be done, that something other than what is expected is there, and that we may need resources not readily available from within accustomed frames in order to understand it. Knowing how to recognize that our own traditions have not prepared us to interpret the ways of other traditions opens up different possibilities for navigating time in its shared and unshared dimensions. That potentially opens up some possibilities for decolonizing how we think. Here's just one possibility. If we think of linear progressive time, the time that just goes in a straight line, not as the only truth about time, but instead of as a structural presupposition of one particular temporal frame, then what it means to inherit a past changes. What I just said in more simple terms is we could teach ourselves to think that linear progressive time is not the only form time takes, but just one way of expressing it. And if we did that, we might be able to rethink what it means to inherit a past. For instance, the fact that the past cannot be undone does not prove that time is linear. Rather, our belief that time is only linear narrows for us what we think can be done about the past. I'll say that again. The fact that the past cannot be undone does not prove that time is linear. Rather, our belief that time is only linear narrows for us what we think can be done about the past. That matters because at every moment in the long story of relationships between settlers and Indigenous peoples, including this moment, different narratives and outcomes were and are possible. Every tradition is a set of beliefs and practices underway, held in place by structures of habit, rule, and tradition. Shifting something that seems settled will not be easy, but there is hope here, because if our systems of meaning aren't unchanging essences, but rather are the result of interpretive processes that are always underway, then they can always be interrupted, because anything that is underway can be interrupted. That's it.
Hi, how are you? So I have 100 questions, but I'm going to go with one that feels more polite. You talked earlier about the genocidal nature of colonization and the laws in place now. And my question is, what's the difference between what you are characterizing as the genocidal nature and the homogeny, I don't know how to say that word, but and then where does that line get blurred, at least in this case, in your perspective?
I think if you're thinking about law having genocidal intent versus there being a hegemony of certain populations over others, that they're just you could say it's two ways of expressing a similar thing. The fact that a population has hegemony means that it has the power to make laws that end up being genocidal. Part of what I wanted to draw our attention to is that if enough people started thinking differently about a lot of basic concepts, including is what we think settled, then it shifts what we find acceptable in some ways, such that even if there's still a hegemony, it doesn't necessarily have to be genocidal.
Okay, thank you.
So I have, I guess, a point and a question. The point is, it's sort of ironic that pre-1982, Canada didn't even have a written constitution, and for them to then be skeptical of non-written traditions, there's just something humorous about that. They didn't have a constitution. The question, and it's not sort of fully formed in my head, but it's about the sort of temporal framing of your talk. So there's one way I was thinking about it, and I was kind of thinking it in sort of Kuhnian terms, and sort of you can work within a paradigm, right? So you have this sort of juridical tradition, and that sort of sets what you're able to do within that tradition, or you can question that paradigm itself, right? So that's one way I was sort of thinking about it. But I could sort of do all that without the temporal framing, so sort of questioning the nature of time. But I take it that's sort of essential to what you want to say. So that's the part. I guess what does that sort of how essential is that sort of temporal aspect of it, and what is that adding to sort of more the sort of more Kuhnian way of putting this point?
It's a good question. I mean, I think the point about paradigm shift, like if we were able to do a paradigm shift, great, right? I'd be all for it. I doubt we'd be able to do it without dealing with all of the things about the past that are unresolved. That's why, for me, the time thing matters. So if you think about how in this room, I don't know what your lives have been like, but we're all probably inhabiting slightly different temporalities. Some of us have let things in the past go, and some of us have found that we aren't able to, in part because of how the present moment is. So to me, the present moment gives an opportunity to people to make it livable for those whose pasts were traumatic or oppressed. And all of us are part of that, and we can do something to make the present moment more livable for people whose past should have been otherwise, or we can fail to do that. And that, I think, is a huge part of a type of injustice that is part of a long string, hundreds of years, that keep going. And so that's one thing. The other thing is that there's this tendency for people to think that everything Indigenous happened a long time ago. And we need to shift that understanding. And in order to do that, we have to shift the way that we think about the relationship between time and indigeneity. So for me, that's why that term matters.
Great. Thank you.
Plus just a lifelong fascination with temporal stuff. Although my husband will tell you that like he's the one who has to tell me how long we've been married. Like I have a weird relationship to my own temporality. Like, which anniversary is it? And then I look at him.
So my question is, since because you like have this notion of time, like I'm just trying to think of the distinction between like this kind of notion of time versus history. So if I think about questions about like everybody thinks Native American stuff happened like thousands of years ago, or kind of relegates it to like the so-called Stone Age of kind of pre-development. I kind of think of this as, oh, we're kind of conceptualizing these like historic events, this kind of Hegelian, and I don't really actually know Hegel, so I should not really say these things, kind of progress in which just things get better through time, or like how we relate all of these events into some kind of oriented or something that works towards something as a system. But I'm thinking like, I imagine settlers and natives kind of agree in time in this more basic sense of like, oh, did this happen at the same time? And like kind of the way we think of it in like physics, and we just like are like looking at stuff in kind of a much more bare, boring way. So like in what sense is like, I assume you mean time in a more sophisticated sense than that, but how is it like distinct from history?
Well, I mean, even physics will tell you that there isn't any privileged standpoint from which you can say two things happen at the same time if you follow Einstein, right? So
But those seem to be a difference in sense, though, where like
yeah.
that kind of difference depends on like how fast you're moving, not like a cultural position.
Yeah. So, I mean, part of the problem is what you point to, what I was just talking about, in the way there's this kind of tendency for people to think something indigeneity happened in a past, and that can surface in a lot of different ways. One of them is just to think it's not a problem anymore because they're all dead. They're not. One of them would be to think that anything that they do that is modern can't possibly be indigenous because indigeneity is something that is ancient. So it would be like, there actually were lawyers in the Mook case who who cross-examined people saying, oh, but you drive a truck, don't you? You have running water, don't you? You participate in the wage economy, so therefore you have become a white person. That's ridiculous. Like, are we still going around in horse and buggy? You know, are we still thinking that everything about what the founding fathers thought was justice is just? So there's this tendency to want to hold indigeneity into this frozen time frame while allowing us to keep moving, you know? And I think that's, I feel like I'm circling around your question rather than getting directly at it, but yeah.
I think my question would be, if being indigenous is as liquid as a construct as we are alluding to today, what is the definition, or rather, is there a universal definition of what is indigenous and what is a settler? Because, I mean, as transparent as an idea as it could be, wouldn't all people be a settler, and then once they are born, they're indigenous?
So there's a lot of ways to answer that, but indigenous in this instance means a member of an ethnic group that has dwelled in North America considerably longer than before the conquest, the arrival of white Europeans on the continent. And many indigenous groups are able to show a long history in terms of archaeological record and in terms of the stories that have been passed down. In terms of, you know, how long does it take before you yourself can be considered indigenous, I think that's almost like another discourse. So in the region of British Columbia where this is happening, there are settlers, Canadians, who have been there for 3 generations, 4 generations, not longer than that though. It's, you know, the western part of Canada wasn't really settled by white people until quite late. So, but they feel they are native to that country because they have roots. They've been there for generations. They don't know another way of life. So some of them think they're really not sympathetic to the claim that they're on someone else's land. But some of them are. They say, "Oh, I guess we did kind of show up and take over. But how do we solve this? What do we do?" And I think that's where the hope is, because when I say that this isn't settled, it doesn't mean that it necessarily is an eviction notice where it just creates a whole other category of refugee. But there probably are ways to work out co-dwelling on land that admit a history of harm and figure out how to deal with it rather than constantly covering it over and pretending that it already is past in a way that we can't address. Does that make sense?
Absolutely.
Okay.
Thank you.
Those keys are like you're a cat wearing a bell.
Hi. You mentioned Merleau-Ponty's idea of this perceptual tradition, and I really think that's interesting to think about. Would you think that perceptual tradition acts in this case as a kind of communal defense mechanism that keeps people from having to accept, the oppressors having to accept that they're oppressing another group? And if so, how do we get them to think about what's settled as unsettled?
Yeah, I do think that that's what it can do. A perceptual tradition can be a frame that we all need frames to a certain extent, right? We can't take in everything that's going on in every moment. Like, that is how the brain works, because it would be chaos. So perceptual tradition is helpful in that it allows you to know what matters to the community that you're part of, and it allows you to know where you should look and what you should see. But what I wanted to point out by drawing attention to it as a thing, as a practice, is that a practice can be changed. Whereas if it were just how the world works, well, then there's nothing you can do about it. So what we want to do is have people aware that their frames, their perceptual traditions, their forms of common sense are practices rather than essences that you could never intervene in. Because if they're practices, then it opens it up for interventions where you say, oh, well, why have I always thought this? No one's ever going to be perfect at interrupting their own assumptions about things, no one. But knowing that you ought to be doing that more, I think would be a good step forward.
Okay, so you would recommend something like episodic change rather than revolutionary
Well,
change.
this is what I'm calling interruptive moments, right? So for me, when if I recognize that the moment when it becomes clear that a song could be legal title for another culture, and I'm like, huh? That's a moment when I need to interrupt what I think judgment is, And if I know that that's a possible thing to do, that I can interrupt what I think judgment is and learn from another culture how that works, then that's better than if I don't think that. Like the judge in the first case, who just thought that he was trained to be a judge in the Canadian in the Canadian bar and didn't need to know anything else in order to make a judgment, whereas some of the judges on the Supreme Court thought differently.
Good. Thank you.
Yeah.
Oh, I'm sorry.
Okay, perfect.
Thanks. So speaking of judgment, I had a practical question about how lawyers and judges in court can actually decide an argument is logical when it's coming from an oral tradition. How do they go about doing that? Is the lawyer arguing on the indigenous person's behalf, or is the indigenous person just giving their story and then they decide whether it's logical or not later?
So in this case, various elders from the houses of the Gitxsan and Wet'suwet'en came in and they performed adawix and were cross-examined and answered questions and said, this is how long we've been on this piece of land, this is where the boundaries are, this is how we establish this is how it gets passed down. Our society is well organized and has been for, a long time. And they had, the plaintiffs, the houses, had lawyers on their side then presenting this and leading questioning and making arguments to the judge. And then also there were defense lawyers who would then do the cross-examining and try to pick apart the arguments and the like. So it's up to the judge. There's no jury in this particular kind of case. It's up to the judge to take all of that in and then make a ruling. Does that answer your question?
It does.
Yeah. One interesting thing that I'll just add that is happening in Canada is that you can now get a JD, a Juris Doctorate in Indigenous law. So over time, it might become the case that more people will understand different forms of law operating within the boundaries of Canada, and that might shift how some of this stuff goes.
Thanks, Jill. I was just thinking, in reference to the question of how can a song be a title, it was making me think about America the Beautiful, the song, and sort of everything that signifies or could signify in terms of the way that it, symbolizes an aspiration that, settler colonialists from Europe had in relation to this land. The beauty or whatever is invoked, or the amber waves of grain, as being this, in some sense, full of that palpable quality of myth and so on. And it was making me think about something that might be an interesting exercise, which would be, what if there was, if the tables were turned and some indigenous elders were sitting in judgment on the story that we might tell that justifies why we're here we're still here as settler colonialists, right? And it would be, I was just imagining, how kind of fantastic that would be, to have the tables turned in the sense of it maybe not being so much, it is a question for you and I think for us too of how we can understand the way they think, but it would be amazing to be interpreted by them, to sort of have to reveal our history to them and have them tell us how that sounds to them. I don't know if that kind of thing has gone on, but I mean, I would love it if that went down, you know.
Yeah, so a little bit it has gone on. There are moments in the trial where things like that happen. In the opening statement, the two representatives of the 54 houses that sued got up and made their opening statement and said things like, well, this is our land, it always has been. About 100 years ago, some visitors arrived and never left. That's what white people are called in that territory, visitors who haven't left. So I actually had a similar idea when I first started thinking about this, that if you could set up a situation where the judgment was going in the other direction. And so about partway through the thing when I said, who gets to judge which story makes more sense, right? So right now, Canada gets to say that its story makes more sense just with sheer brute force. But if you actually look at what a lot of the Indigenous groups are saying, they're saying, don't clear cut the land. That means that everything's dead and there's nothing for a future generation. It's not only true for them, right? Like, the earth is being killed by the way that settler colonial reasoning goes. So you would think that there would be lots of reasons why one could think about how different forms of judgment would get us a different outcome. A reason why something like this might not happen, I'm never going to know enough about these cultures in order to put out what that judgment would look like. And then the elders themselves aren't interested in doing that kind of judgment because it's culturally not what they're about. They're not about saying, your culture is wrong. It's about saying, here's what our culture is and here's how we sustain it. It's not even really about telling people within their culture what they can and can't do, but about how everybody learns from the stories. So it's different enough that kind of judgment, that kind of project of reversal is itself, the fact that it can't happen is also an indicator, Maybe not can't, but unlikely to. Yeah.
A really, really good talk, and I've been thinking about what you had to say and a lot of the questions. And I'm not sure whether it's one question in two parts or two different questions, but I'll throw it out anyway. I guess you've talked a bit about genocide, and I wonder if you could reflect about the very kind of broadening, stretching of the definition of genocide, which I think is actually something that's going on with genocide scholars today, and how you see your work fitting into how we're redefining genocide. And then going back to some of the questions that have been asked, and back to Nathan's idea of the paradigm shift, I wonder if you can sketch out if there were a paradigm shift, how we can bring these. I'm sort of wrestling with how incompatible are these two systems, if it's a binary, and what you would see in terms of how that paradigm shift might look if we were able to successfully kind of make that adjustment. Does that make sense?
I think so.
Yeah.
You mean like what would be the outcome if the case went well for the Indigenous groups?
Yeah, or maybe even going sort of broader than that, but if we were going to make a true paradigm shift and move from essentially the settler kind of colonialist idea of its legal system being predominant, if we were actually going to move to one that, I don't know, combines the two systems, accommodates them in ways, are they incompatible? Is it going to be a very different?
Yeah.
Interested to see that sketched out, actually.
Yeah, well, I don't know if I'm going to be able to give a great sketch, but so it would be there'd be legal pluralism, but also there would be a healthy knowledge of the limits to what law can get for anybody. Right now, I think we're all suffering from a kind of metastasis of relying on law to solve problems. So to get past that would be good, but to know what law is good for and use it only for that but allow that there are different ways to build law and that those different ways might reside amongst each other. I mean, to me, it's also interesting to think about how we could rethink what it means for there to be boundaries between cultures. What if two cultures could live in the same territory and have an understanding of boundary that wasn't a line on a map, but was just about jurisdictional agreements? I mean, there's all kinds of sites. I'm sure some of them are coming to mind right now, where if that were a possibility, a lot of problems would, if not be solved, at least be thought to be workable. You know, so I think that that's a super sketchy, but
Yeah. No, that's interesting.
Hey, I'm just kind of interested in what you think the consequences of legal pluralism might be. Because I just can't, really imagine a world where, two really distinct cultures could kind of get along with, would they have, do they have to agree on certain laws? Do they have to have, a person of this culture can do something that another can't? Wouldn't that cause frustrations and just something I'm really worried about?
Yeah, that makes sense. Although right now we saw that problem exists, but it exists in a world where boundaries are things you can draw a line in a map about, right? So there's all kinds of things. If you go to another nation, there's things that you can't do there that you might be able to do here because you're under their jurisdiction while you're there. How that ends up working, if my utopian idea about people being able to dwell amongst each other with different jurisdictions, I'm not sure. I mean, it's just going to cause. There's always going to be stuff where it's clear what the answer is, and then there's going to be stuff where, how do we handle this? That's how law works. A lot of times, law works by applying rules that everybody understands, and then it doesn't end up going to a court because everybody knows here's an infraction. Oh yeah, that's an infraction I did. Here's your fine or your jail time. But it's the stuff that doesn't get solved that easily that ends up going to court. And maybe there would have to be special international courts, right, between these shared jurisdictions to deal with those types of cases. Because if you think about it, there's a way in which this case between the Gitxsan and Wet'suwet'en and Canada maybe should have been tried by an international court. If the Gitxsan and Wet'suwet'en are actually claiming sovereignty and are on land that has never been ceded, right? This land has never been ceded by treaty, so it's been theirs. It's not like them taking it back. It's them trying to assert, well, how does this work with your sovereignty? And Canada being like, what? I can't hear you, right? Sovereignty. So it's not a clear answer because I don't think a clear answer is possible. But one wants to give people the power to imagine that something that works is possible rather than something that constantly doesn't work, be the only thing that we're left with. Does that make sense? Aspirational.
I actually want to re-ask the first part of Stephen's question about the shifting nature of genocide and how you see yourself.
You're right, I didn't answer that. Right. I'm not sure. I would love to hear what you guys think about that. So I had a friend of mine who's an international lawyer read this paper and kind of give me comments, and his comment was, I don't think you should use the term genocide because the Genocide Convention didn't happen until the mid 20th century, and a lot of these crimes actually predate it, so therefore it wouldn't apply. And I'm like, well, that's a mighty legalist way of answering that question, But I was like, on the one hand, I understand it because that is how law works. But on the other hand, I'm not a lawyer, right? I'm talking about, well, what is the actual impact and outcome of these legal procedures? It is genocidal, right? But in terms of how to make it perhaps more nuanced according to what a lot of people have been writing about genocide lately, I would rather hear what you guys have to say, if you have something. Yeah.
Go ahead, Karen.
Actually, I'm going to steal off of Stephen, and I kind of have a question that may be two separate questions. But the first is when you were, talking about genocide, one of the things that came to my mind, partially because of a book I'm reading now, this difference, or is there a difference, and can it apply legally between the terms genocide and ethnic cleansing? Because a lot of what you were describing at least in a lot of the literature that I've been reading now, most people are tending to go on that ethnic cleansing side, like the idea of wiping a culture out without wiping the physical people out, if that makes any. I am not a philosopher, so I apologize if my terminology is off there. But the other part that I wanted to ask was when you were talking about sort of the interruptions and kind of shifting people, how people can shift their thinking. The one sort of framework that came to my mind was this idea of narrative theory, especially with oral histories, that you're going to take from a narrative, you're going to take out of it whatever experiences you have personally had coming into it. So that even with those oral histories that were performed in a courtroom, everybody is going to take something individual out of it based on their life experience up to that point. So in that case, even if you're giving people a new experience to add to that, do you think it's still possible to, do you think there's still the possibility that, for example, the court system in Canada or that one crazy judge from that first case, could their way of thinking truly change if they're still going to be clouded by their life experiences up to that point in analyzing what's before them?
Yeah, those are both good questions. So I know that there's all kinds of definitional stuff that matters here, and usually as a philosopher I'm super careful about that stuff, but in this instance, isn't ethnic cleansing just what people say when they're avoiding saying genocide? So in which case, obviously it matters whether people are just wholesale murdered or have or are pushed somewhere else. But pushing somewhere else is also an attempt to take away a stable capacity to pass on a culture to a next generation. And when you think about how ethnic cleansing also often involves mass rape, that's another way in which people try to destroy cultures by, So I'm not quite sure that distinction ends up giving me anything helpful, but I'd love someone who has who wants to do a nuanced reading on it to do that for me, so that I can then read that thing, right, and then use it. But I don't want to do that. Right? Okay, someone else, please do that work for me. Okay, I'm going to answer part two. All right. So and then the narrative thing. I think that's a really good point. It's always going to be a problem, right? So I've inherited a bunch of things by the way I was raised and how I've been trained and with the books that I've read. There's a lot that I can learn from giving papers in rooms like this with a lot of different people who ask me questions I couldn't have foreseen and then pushes me to think differently. But I'm never going to fully escape my inheritance. It's who I am. But knowing that I ought to be trying in certain settings is what matters. If I'm so confident that I just know everything I need to know about the world already, that's just insufferable. And it's not tending towards justice, right? So that's what I'm aiming at. It's not being perfect at always seeing what I don't see, but being better.
I'm sorry. We have to give up the room.
Oh.
It's one of those things.
Thank you, everybody,
so
for questions.
Can everyone help me thank? Thank you all very much.